We can have your attention, everyone. We're going to get started tonight, just a couple minutes behind our intended schedule. But welcome, everyone. Welcome to tonight's City Attorney Candidate Debate hosted by the League of Women Voters and hosted by the League of Women Voters and the Oakland Metropolitan Chamber of Commerce. My name is Paul Young. I'm the Vice President and Director of Public Policy for the Oakland Chamber of Commerce. And before we get started with introductions of our moderator, our panelists, and our candidates, I just wanted to be able to say a few words and make a few introductions and a few thank yous. I first want to thank a chamber member and our host tonight, the Waterfront Hotel, for providing this beautiful venue for the event tonight. And I want to encourage any of you that haven't already had a bite to eat or grab something to drink. I did that beforehand, and the food was great, and I encourage you to do so after the event tonight. I also want to thank the staff and members of both the League of Women Voters and the Chamber of Commerce for the planning, the preparation, and all the work that goes into putting an event like this on tonight. I want to introduce now the two panelists who will be posing many of the questions that we have tonight. One of our panelists from the Oakland Tribune is Matt Artz. Our other panelist is a chamber member from the East Bay Rental Housing Association, also a very active community member and resident in District 4 of the City of Oakland, Jill Broadhurst. And I wanted to mention that while Matt independently, of course, came up with many questions, the Chamber of Commerce and our Public Policy Committee collectively worked on a number of questions, and so many of the questions you'll be hearing from Jill are questions that are being posed by the Chamber of Commerce. Well, so now it is my pleasure to introduce to you the President of the League of Women Voters for Oakland, Catherine Gavsey.
Thank you. Welcome again, everyone. It's a pleasure for us. This is the second time we have co-sponsored a forum with the Chamber, and they go really well. And we're pleased to have you all here. In addition to questions coming from these panelists, we will have a couple of League volunteers raise your hands with big buttons say League of Women Voters, going around with cards. If you have a question you would like to pose to one of the panelists, one of the candidates, give it to the volunteer who will bring it to us, and we'll give it to the moderator. We can't promise we can get everything in, but we will do our best to get all the pertinent questions presented to the candidates. Thank you so much for coming again, and please, as you leave, pay attention to the table at the back of the room. If you're going to be an informed voter, you also need to be a registered voter. We have voter affidavits there, registration affidavits. The deadline for registration to participate in this election is October 22nd. If you have moved since the last election, you need to re-register. So please take advantage of that opportunity. And while you're there, take a look at all the other information that we have from the League of Women Voters. We are an organization of men and women working to keep democracy strong in the City of Oakland and elsewhere, and we would love to have you join us. So if you'd like to learn more about the League, take a brochure from our table at the back as you leave. Thank you again. And I would now like to introduce your moderator, our moderator, Helen Hutchison.
So, welcome everybody, and I want to thank the Chamber of Commerce for sponsoring tonight's forum and for making this a great success. We have tonight two candidates for the office of City Attorney, Jane Bruner and Barbara Parker. The format will be that there are going to be two separate rounds of questions. Each candidate will have 2 minutes for an opening statement. And Ms. Bruner is going to go first, and then Ms. Parker, and then we'll reverse the order for closing statements. There'll be 2 rounds of questions. The first will come from our panelists, and the second round will come from you. Each candidate will have 1 minute to answer the questions, and we will reverse order, just go back and forth who gets to go first on those. We have 2 timekeepers down here in the front who will signal the candidates when they have 30 seconds or 15 seconds left. And so I think we're ready to begin. Ms. Bruner.
Thank you. I'm Jane Bruner, and I'm running for Oakland City Attorney. I have been on the City Council for 15 years and a practicing attorney for 25 years. I have the endorsement of Assemblymember Sanjay Swanson, Councilmember Desley Brooks, former City Manager Robert Baum, Phil Tagami, Oakland Police Association, Oakland Firefighters Association, Local 55, and many other individuals and businesses endorse me. I am really proud of many things that I have done on the City Council. Recently, I negotiated the Army base, which is going to bring thousands of jobs, and it's a billion-dollar project. 50%, I helped negotiate that 50% of those jobs will go to local residents, and 50% of the contracts will go to local businesses. I have started the One-Stop Resource Center for new businesses coming to Oakland, and I have recently introduced the One-Touch inspection. I am running for city attorney because I have watched that office for 15 years, and I truly believe that office needs to change. I think it is bureaucratic. It's much too slow. If you talk to many businesses and residents, it can take months, even years to get contracts done, and a long time to get an answer. The settlements are done way too late, so they cost us more money. It's a very big office. It has 70 employees, 35 attorneys, and last year spent $6 million on outside counsel. When you compare it to other cities of the size of Oakland, it is much more money on the operation side than other cities. I believe that I will be an activist attorney. I will work on consumer fraud, elder abuse, business rules. I believe I'm the right person. I have the legal background. I am a fighter, I am a doer, and I'm an implementer, and I will make that office, help make that office change. Thank you.
And Ms. Parker, and I failed to say that Ms. Parker is having some problems with her voice tonight, so if everybody would please bear with her, we're going to do the best we can with microphones.
Okay, thank you. Good evening, and thank you for this opportunity. My name is Barbara Parker, and I am the city attorney. The council appointed me a little over a year ago, and since that time, I have been serving the residents and citizens of Oakland. It's been a long road to get here. My parents grew up in the rural segregated South, but they instilled in us the importance of hard work and education and justice. I'm the first generation of my family to go to college, and I graduated from Harvard Law School. When I took office, I focused on 3 priorities: public safety, streamlining services, and being a watchdog to assure that practices are fair and honest in City Hall. We've done many things this year. We've had great successes. Examples: I went to court and shut down 2 hotels that were centers for prostitution and child sex trafficking. It's made a huge difference to the residents and businesses in those communities. We cut the cost of outside counsel by nearly 40%, despite the fact that the council has cut our staff by more than a third. We reduced payouts for settlements and judgments by nearly 50%. And I have taken steps to assure that everyone knows and plays by the rules, regardless of political influence or power. The city attorney is an elected position, but it is also a professional position. It's critical the city attorney have broad experience and expertise and knowledge of the law, and the professional judgment to assure that difficult decisions can be made appropriately every day. That is the work, and that is the job, and the expertise I bring to this office. Thank you.
So we're going to move now to questions from our panelists. Jill, you go first, and we're gonna Jill, and we're gonna ask you to speak up because we don't have a microphone for you.
That's fine.
Okay.
That's fine. Okay.
The first question is going to Ms. Parker first, and then Ms. Parker.
Okay. The city attorney's office is criticized for excessive use of outside counsel, which you just referenced. City attorney annual report of fiscal year 2010-11 report shows that outside counsel cost us close to $6.38 million. But of course, there's a caseload to manage, and the city council authorizes a certain number of attorney positions. So is this excessive use of outside counsel critique fair? And what should be done about it if it is excessive?
As I indicated, the city council makes the policy decisions on the budget, and the city council has made a decision over recent times to cut our office by more than a third. The legal work does not reduce because of that cutting. In fact, it is increased. And as a result, the City Council is making a decision to outsource to expensive legal firms. We have no choice but to defend the city in lawsuits and to provide the critical advice that we provide from an day-to-day basis. So I think it's not excessive. And in fact, we have been arguing for years to bring more attorneys back in-house so that we can be more efficient and effective, and that would save money. The city attorney uses outside counsel. It's $250,000 for a motion for summary judgment by an outside counsel, which is more than the cost of a journey person attorney for a full year who could handle that motion and many others.
Every department, the City of Oakland has cut $190 million, 400 positions. Every employee gave back 10%. Every department was cut. The city attorney's office, the attorneys were cut. But instead of streamlining and cutting, they went out and hired outside attorneys to come in, which are more expensive. Everyone needed to cut. I'm an attorney. It's nice to employ an attorney. I'd rather be employing police. We need to spend some of that $6 million on hiring police and fixing our potholes. I just looked up Fresno, same size city, for around 400,000. On operations, legal operations, including outside attorneys, they spend $8 million. The City of Oakland spends $20 million. That's more than double. We need to streamline. We have one helper for each attorney. I come from a law office with computers and emails. I come from a law office where we have one helper for 4 attorneys. These days, attorneys don't need a one-on-one. You need it when you're doing a big summary judgment or a big case.
Okay. Matt, your turn.
Earlier this year, the City Council agreed to pay the $40,000 penalty a judge assessed an Oakland police officer found to have illegally strip-searched 2 men. The city was under no obligation to pay the penalty, but chose to do so. Ms. Parker, why did you recommend to the City Council that the city pay the $40,000? And Ms. Bruner, why did you cast the vote in favor of having the city make the payment?
Thank you. I first, when it came to us at first and it was recommended we pay for it, I actually agreed that we should pay for it. And then in retrospect, I went back and I thought about this. I believe that police officers have an incredible, dangerous job, and we need to support them. If they did something wrong, they are an agent of the city. I don't believe their family should suffer financially. I think they should be disciplined. If he did something wrong, he should be suspended, or even terminated if it was that wrong. But I don't believe that money should be taken out of that individual's pocket. So I did change my vote and decided that I believe that the morale of the police officers was so low that they were worried that when they get to the street, if they did something wrong, that their family was going to suffer financially. And I believe, and I did change my mind, decided to indemnify that officer.
First, let me be clear that we did not recommend the payment of the punitive damages in this case. This comes up rarely, because it's rare that the court issues a punitive damages award, which is to punish the individual. What we do in those cases, and I know of only one other in history where this has come before the council, is that we advise them with our expert advice of the law and the requirements under the statute. And it's the council that makes this decision, which is a policy decision. And that's what we did in this case.
Under the leadership of the previous city attorney, 2 gang injunctions have been established in Oakland, one in North Oakland and the other in Fruitvale. Do you support these efforts, and would you support future gang injunctions, and why?
Oakland is in a public safety crisis. I think there's no dispute about that. And in a crisis, we need to use all tools that are available to us, at least examine them, and as long as they're constitutionally sound and consistent with our values. In this case, the gang injunction is a tool to achieve an end. I'm comfortable with the policy that the city established, which was to continue with the 2 injunctions that were already in place. And I'm also comfortable with the decision of the council not to authorize further injunctions unless and until a cost-benefit analysis has been done to assure that it's worthwhile and effective.
Thank you. When the North Oakland Gang Injunction and I was brought into a meeting, I actually asked the city attorney's office that I'd like to meet with the city attorney's office in ACLU because I knew in San Francisco they had an agreement about the rights of the gang members that they had worked out with between the city attorney's office and ACLU. That meeting never happened. The North Oakland Gang Injunction happened. As far as I understand, nobody's been prosecuted from the North Oakland Gang Injunction. Then there was a gang injunction implemented by the city attorney's office for Fruitvale. It cost $1 million to defend. It was not brought to the city council to ask for that at that time. I learned, the police officers tell me that, and right now I think it's just been implemented, police officers tell me they don't need a gang injunction. Almost every gang member is on probation, and they can easily get what they need from using the probation rules instead of using a gang injunction. So I think we have to be careful how much something costs and what the benefit is. But, so my opinion of the gang injunctions, I don't think it's been that useful, but as a city attorney, I would absolutely defend it because the city council voted for it, and anything they vote for, as a city attorney, I would defend. Just like the death penalty, when some people have to defend that, and they may not believe in it, but they defend it at the state level.
Oakland spent nearly $10 million last year in police-related legal costs. That's equivalent to the annual cost of about 53 officers. What can the city attorney do to reduce those costs? And should the city attorney take more of these cases to trial to send a message that suing the city doesn't guarantee a settlement?
I think we have to do two things. I think, I'm going to start with second piece first. I think that when an officer does something wrong, we need to settle. But when an officer is following the rules, I think we need to litigate. I think we don't need to, we are the deep pocket. Anyone knows that if they are touched by an officer, they can come sue the city. So I think it's important that sometimes we litigate. Right now in front of us, there's a multi-plaintiff new lawsuit. I asked for some simple analysis of what did each person do and what did the police say what happened. I have not been able to get that analysis, and we're thinking about settling for multi-million dollars. I think for the negotiated settlement agreement, the top attorney needs to be in that room. It's been 10 years. We need to make sure that those officers are meeting the goals of the negotiated settlement agreement, and that will actually help lower our lawsuits against the city.
So I just wanted to correct something in the last statement that my opponent made. The city spent $100,000 in defending the gang injunction. This myth of $1 million never occurred. The second phase was handled in the House. In terms of the judgments and settlements, it takes the professional judgment and experience that I and my trusted attorneys have to determine when to settle and when to fight. This is not a cookie-cutter situation. It requires the judgment that we bring to each case. The facts show the following in terms of our activism. 7 out of 10 claims are resolved for zero payouts. 92% of claims never turn into lawsuits, and 61% of the cases are resolved in litigation without any payments.
Oakland has opened an investigation into accusations that the department's federal monitor recently made inappropriate statements to city leaders. Attorneys for the city did not detail the accusations or reveal which city officials leveled them against the monitor, Robert Warshaw, in a motion filed late Friday in federal court. How does this complicate the city's effort to get out from under federal court oversight for OPD?
This is a pending litigation matter. It is before the court. It is a confidential matter, and I therefore cannot address this at all.
I don't know anything about it, so I can't address that. But I do know that I was in another debate with Ms. Parker, and I want to be clear. I do not think that we want the city of Oakland to be taken over by a federal judge and our police department. When that happened at the state level with the health care, you lose control of your budget. We have only $28 million discretionary funds. If a federal judge or a monitor says $10 million needs to be spent on the police, that means we're going to close libraries, close senior centers, and many other things. Ms. Parker said at the last debate I was with her that she didn't have an opinion. Should we be taken over by the federal government, federal judge, or not? But I think our city administrator does, and I think our chief of police does. And our chief of police and our city administrator said they don't want to be taken over by the federal judge. And I think we have asked, I know I have asked, for legally, what can we do? No other city has been taken over by a federal judge on police issues. So I think we need an analysis of what our legal rights are, and if we have a way to be able to fight that.
So, one more question from each of you?
We've got a few more.
Got a few more? Okay,
Yeah,
go ahead.
yeah.
So,
Go.
next question then.
Another NSA one. You were both with the city, I believe, when it signed the negotiated settlement agreement that ended the Riders case. In retrospect, was it a mistake to enter into that agreement?
Absolutely. I will never enter into a settled agreement like that again, and would I recommend it? It was recommended by the city attorney's office. It was to settle a very bad, cops that were doing some very bad things. It was an outside, and we should have waited. We should have waited till the case was over and figured out what we really needed to do. And the reason it's bad, we need to change behavior. That's not what's bad. What's bad is that it's taken 10 years, it hasn't been implemented, and I believe the city administrator needed to be at the table the whole time, and the top city attorney needed to be at the table, so that we were not still under a negotiated settlement agreement to the point where we're almost being taken over by a federal judge 10 years later. So the key was that if we entered this, we needed to have more leadership to get us out of it than we have been able to provide.
The negotiated settlement agreement was entered into in 2003, and it was a decision that the council made under the leadership of then Jerry Brown, Robert Bobb, and the other leaders of the city, namely the city council. It was supported and voted upon by my opponent. At the time, the city was exposed to huge liability. And the city attorney, I was not the city attorney at the time, I should point out, I've been city attorney for a year, but the city attorney negotiated a deal that saved the city millions of dollars so that this settlement was paid out of insurance funds. Secondly, I think it was a good decision at the time. In retrospect, one may say it didn't work out because the city has not been able to achieve full compliance. But the city is working hard. I'm at the table. We have a team of 4 attorneys working on this, and we're continuing, and we have been successful in keeping the city out of receivership for all these years.
At city council meetings, the city attorney is often called upon to advise council members how to proceed. That advice is sometimes ignored. What can you do to help city leaders stay out of trouble and follow the law and proper procedure?
Well, we give the best and the soundest advice, and I think often it is followed, but sometimes our advice is not followed. And our job as advisors is to make sure, as I said, that the council and each council member is aware of and knows what the law is. I believe that in my first year as city attorney that I'm making great headway in developing a partnership with the city leaders. They're listening more. They're involving us earlier, which is to the benefit of the city. And so I think my skills, my expertise, and the experience I bring of more than 35 years of practicing law in both private and public sectors have been making major headway in this short time, and I plan to continue this work.
I think it's interesting that Ms. Parker keeps talking about this 1 year, which she's been in the city attorney's office for 21 years. She was second in command for 10 years. She was at the dais almost every council meeting. for many, many years. So I think the record is longer than 1 year. What an attorney needs to do is let the decision makers make the decision. There are 4 clients. There's the mayor, the city administrator, the city council, and then there's businesses and residents. And an attorney role, and the role that I play with my clients, is to give options. If there's an idea that somebody wants, you give them options. You can do this, and here's a risk. You could do something else, and there may be a greater risk. Or you could do a third thing, and there's even a greater risk. But it's the decision maker's right to make the decision. You lay out the case law, you lay out the facts, but you don't need to manipulate to what the answers are. And it frustrates me when attorneys do that. I think the real thing is that the decision makers, and there are different decision makers at different points, are the ones to make the decision once you provide them the information.
Yeah.
Okay. Last year, Mayor Kwan retained a private attorney to advise her rather than the then City Attorney John Russo. Do you think that that was appropriate, and what would you do if Kwan or a future mayor did the same thing while you were City Attorney?
I can go first.
Yeah, because she was last, so that's how it works.
And this is for me anyway, so I might as well answer it. You know, everybody gets a right to have an advisor. There was only one city attorney to give official opinion, but you get to have an advisor. Did I think it was smart to have an advisor? I think it was fine. Where I think it went off was, and Dan Siegel and a lot of people in this room know that I worked for that law firm. Where I think it went off was when Mr. Siegel started publicly making comments and wasn't just advising the mayor. At that point, I actually went to Mr. Siegel and I said, I really think you need to step down. Because you can't, if you're an advisor, you're an advisor. And you can say things. You can't go into, you know, if he went into a room and started functioning as an attorney, that was inappropriate. And I, at the time, said that was inappropriate. Dan Siegel is probably one of the best attorneys in the state of California. I think being an advisor is fine. Stepping over the line to trying to be the city attorney was not appropriate, and I told him at the time.
Ms. Bruner has been with Mr. Siegel's firm for many years, and she remained with him during this debacle. The actions that our office took would be the same ones I would take. Mr. Siegel appeared in court on behalf of the city, and we had to go to the court to have the court issue an order precluding that. Mr. Siegel issued a legal opinion providing advice, which, by the way, was erroneous, and we had to reverse that. We went directly to Ms. Mayor Kwan, and we took this matter to the council, and she eventually relented, and she has not repeated these activities since I've been in office.
Do you still have questions? Okay, because I've got some too. So how about one more from each of you, and then we'll go on.
How do you see the role of the city attorney's office in policy making while serving as the advisor to the city and council?
Ms. Parker, you're first.
The city attorney has a specific role, and that is to provide clear, succinct, sound advice. We also work creatively with our clients on their initiatives, so long as they're permissible legally. The council makes the policy decisions, and I have consistently shown my ability to provide impartial, sound advice, and also to work creatively with my clients. We also have the option to present policy proposals, which we do on occasion, but it's up to the council to make those decisions. So there's no role for the city attorney in policy-making decisions.
I agree that the city attorney is not a policymaker. The city attorney is there to provide legal counsel. But I have observed the city attorney playing with what can legally happen and not legally happen, sort of doing policy through law. And Goldman Sachs is the last example. It was clear there were community groups and council members who wanted to say that Goldman Sachs swap should be terminated. and that after it was terminated, if it's not terminated, that we didn't want to do business with Goldman Sachs. The first report that came out was that the city attorney's office said, you can't do that. After the council did vote to do it, a second public city attorney report came out and said you could do it. So there is, I think it's not appropriate to do that. I think you leave the policy to the policy makers, but it is helpful to understand politics in a political world, and the city council and the city is in a political world.
We have opportunity for rebuttal. I'd like 30 seconds.
30 seconds each? We'll do 30 seconds each, okay.
Okay. This is an outrageous statement that was just made by my opponent, and it shows the difference between us night and day. She just announced to this audience the substance of a confidential legal opinion that we provided to the council. And she stated it erroneously because she believes that I, as city attorney, will not be able to reveal the truth of our opinion. Let me be very clear. We are very supportive, as I think all of us in this room are, of going after Goldman Sachs, other banks, and others who have fleeced the people of this country. That is not the issue. Our job is to provide sound advice, and what we did in this opinion, which is now a public portion of it, was to tell the city council the steps it needed to take to accomplish the end of stopping doing business with Goldman Sachs. There is something called due process in this country, nevertheless.
Well, you can clap and you can call me names, but let me tell you something. What I said was public information. It was at a city council meeting. It was many people speaking to it. I was asked by people to talk about what was in that opinion. I never did. I was asked by reporters for copies of it. I never gave it. But it was known what the end result of that opinion was, and you can go back and look at the tapes.
Okay. Earlier this year, the city attorney's office warned a council member that she may have violated the city's charter prohibition against directing city staff members. As city attorney, how will you, either of you, make sure that this rule is followed, and do you support additional powers for the city to enforce the rule?
I'm losing track of who's. So why don't you go first? Jane. Okay, good. I'm glad somebody's keeping track.
Very well, very well.
Thank you.
You're welcome.
I think it's complicated. And let me tell you why I think it's complicated. I don't think we know all the facts that went on the teen center. You had a city council member who was desperately trying to get something done. If you read the emails that were put out, she informed staff all along the way. She actually took the city administrator at the time on a tour. She may have done something that was wrong. I really don't know. I couldn't tell from the facts that I got. I think it's important to work with people. I think what happens often is, as council members, residents call you and ask you to do something. You don't request it, it doesn't mean you want it done, but you pass that information on. Some staff members think by a city council member passing it on, you're directing them. You're not directing them, you're just asking them to work on a project. I think it's been clarified, I think that's good, and I think that there should not be interference. I have spent my career very seriously trying not to interfere and having staff provide its own job, doing its job.
It's critical that the voice of the people in enacting the city's charter be honored. And in the charter, it's clear that council members make policy, pass legislation. They have no administrative powers. It's their job to make that policy and then let the administration hire and fire, enter into the contracts so that they're fair and competitive. I issued a memo to make it clear to everybody what the rules were, although I think they're perfectly clear in the charter. It became a big issue because apparently there has been a fair amount of interference. And I would continue to support that position. But ultimately, my job is to advise so that the full council is aware, and then people make their own decisions and suffer the consequences.
I'm going to do a few of the questions from the public, and we may come back to our panelists then. And so the first question is, if the city attorney has 4 clients, mayor, city council, city administrator, businesses, and residents, I think that's 5, but what do you do when these clients disagree or have differing interests? So you're first.
We face this issue every day, and it's a case-by-case analysis. In some cases, it's clear what the law is, and whether there's a dispute or not, it's a clear opinion that's provided to all parties. If there is an actual conflict of interest, then we would retain outside counsel to represent the party, the appropriate party.
So I think your job is to give the options to each of your clients. And I think that each of those clients get to decide. And, you know, the mayor gets to make some decisions, that's within her purview. The city administrator gets to make some of those decisions, that's within the role of the city attorney. The city administrator gets to make. Some of those decisions have to go to council. So I think what you should be doing as a city attorney is providing the information along with the law and letting each of them, along with the rules of when they get to make that decision. If it's an administrative, the administrator decides it. If it is a policy or budget decision, the city council, and it takes 5 votes, and they get to make that decision. If you want to work with businesses or residents, you can give them some options of what they can do, but eventually they have to either have the mayor, the city administrator, or the city council implement what they want. So I think the goal is to give options to each of those clients and let them be the decision makers, because they are the decision makers.
Next question here is, what role should the city attorney take in improving records management in Oakland in order to facilitate accessibility, and I would say both for the staff and for the public?
The records absolutely need to be fixed. The fact that I'm stepping down from city council right now and I'm thinking about what records do I need to keep, what records don't I keep. Some years ago, I think it was John Russo and the city auditor who came to the city council saying, we need a record program. At that point, they wanted all record. I don't remember exactly, but there wasn't a consensus. We asked, and the city council at that time said, we would like a committee with the city clerk, the administration, the city attorney's office, and the auditor to go off and figure out what are the rules about record keeping and bring that back. That has not been brought back, and I don't know why it hasn't been brought back. It should be brought back. We do need clear rules about what records we keep and what records we don't keep.
I think records management is a key issue for the city in terms of both defending the city when there's litigation and in terms of transparency. Under my leadership, we are proposing, and we have proposed in the past, that we have a searchable record system so that online the public could search what requests have come in and they can see what answers have been provided, so there's not the necessity of duplication. We also have brought to the council on several occasions a records management policy that would retain records long enough so there wouldn't be issues with litigation, and that has never been scheduled. So I'm a very strong supporter of this and think it's critical for the actual stakeholders, the voters and the residents, to know what's happening in City Hall. And we need to improve it. And we've done everything we can.
At this point, I'm going to ask you guys for some more questions.
Okay. Jean Kwan has proposed, or at least said she's going to propose a youth curfew. As city attorney, how would you advise them towards the legality of a youth curfew? Are there any legal pitfalls when it comes to implementing one?
It's not true. Call it curfew. It's not.
Loitering? Go ahead.
Loitering.
Let her answer, she can correct it.
Let her answer.
She can correct it, if that's the
Okay.
case.
She's a city attorney.
So I'm taking this as a hypothetical question. if the mayor asked to bring a curfew forward, what would be the city attorney's role? And our role would be the role of analyzing it, determining the constitutionality, and working with her on the policy to assure that it, in fact, achieved its goal. We had a study that was done a few years ago when curfew was raised, and it was determined that the city was not going forward with it because the issues of truancy and crime were occurring in broad daylight right after school and up until dinner time. So one of the issues would be the effectiveness of the program, as in addition to its legality.
I have not studied the legal research on what is legally you can do for loitering or curfew, so I don't want to answer that part. I do think that the most frustrating thing for residents in Oakland is that you have young people standing on a corner, intimidating you, and drug dealing right in broad daylight. They may get arrested, and then they're right back out on the street. So I think there's a difference between loitering and curfews, and I think that we need to look at what the rights we have, in the loitering, where it has worked and it is legal, is in front of stores, and different places where you're asking people to stay away, and working with businesses to report that. I'm a little concerned about the curfews, not so much as I just don't think our police department is so overworked. So we need to make sure if we're going to put something in like curfews, and I'm not opposed to curfews, but if we're going to put it in, the issue that Ms. Parker brought up is the issue, I don't know if she brought it up, but the issue is what happens to them. Where you pick them up, where are you going to take them? You're going to take them back to school, you're going to take them to their parents, they're not going to tell you their parents, you're going to take them to jail. There are a lot of issues you have to work out.
You've answered this one. Okay. I'm sorry. I'm looking at questions and forgetting. So do you guys...
We still have more, but
Go ahead.
Okay.
Yeah.
We asked earlier about recent developments in the federal oversight of the OPD. Generally, what will you do to see that OPD remains under city control and the federal oversight is brought to an end soon?
There's two parts to that. One is there really needs to be a serious analysis, and I haven't heard it in all my years of watching this and listening to it, why they are not out of the negotiated settlement agreement. We get checklists, like they got that, they have 57 items, they have 13 items they completed, some they're not fully completed, but something is deeper. Something is not working, that they're not out of it. And we really need that analysis that needs to be done by the police department. And I think the city administrator and the mayor and the city attorney needs to be part of it. I also think we need to do an analysis of what the legal rights are for the city in challenging in case there's a takeover by the federal court. Once we do that analysis, then we can decide, is there anything we can do? Is there nothing we can do? What would be the cost of doing it? What's the risk of doing it? And I think the first thing we need to do is do that analysis of what can you do as a city if this is something that's coming in front of us.
The city attorney, as I said, we have a team of 4 attorneys working closely with the mayor and the city administrator on the NSA. And we've been working closely for years. We provide advice in our role, and we work with them to assist them in developing the policies that are needed to comply. Ultimately, it's the police department that has to actually achieve the compliance. But in terms of our role, because of our assistance and advice, as I indicated earlier, the city has not been put into receivership, and the city has been moving closer and closer to full compliance. And I think that it is ideally in the interest of the city to run its own operations. The court has become frustrated over the years, and so compliance is the key piece.
I'm going to do another audience question here. Is the city attorney required to defend the city council or mayor if they act against the city attorney's advice but follow their conscience? And I would say if they don't follow your advice, what are your obligations then?
It depends. This is a case-by-case situation. If we provide advice and the council takes a different direction, and it's not illegal, and they've made a legitimate policy decision, then whether we agree with that decision or not, it's my job, and we have consistently represented the council in providing that advice. On the other end, if what is being asked is something that is not permitted or illegal, then we would not be able to proceed in that fashion. And there are also situations in which we might need to have, conflict counsel, depending on what the issues are. If for some reason there was an issue that the city attorney felt it could not represent the council on.
I think you're obligated to represent the city council, and it is their decision. The city council may push the envelope. It has pushed the envelope on tobacco, on marijuana, on several things. But it is their decision, and you need to go along. The city council recently wanted to do cultivation of marijuana, and they wanted to do it because they wanted to get the marijuana growing out of the houses which are more dangerous than in being in the flatland. The city council, the city attorney's office at that time did not want to do it. They actually sent a letter to the federal government asking if it was legal, which made it very difficult for the city council to do it. So not only did they not advise the city or help the city council, they worked against the city council. I don't think that's appropriate. If they feel that it's illegal and they don't want to have their reputation on it, it is correct. Conflict, outside counsel or different counsel needs to be provided, and that was what was happened at that time. But I do believe your obligation is to represent the city council.
I have one more here that I'm going to do. What are your ideas about the 2011 grand jury critical report on city permitting? What role would the city attorney play in remedying any of those problems?
So the city permitting, when the grand jury, and I'm trying to remember the details of the permitting, but let me tell you what I did after that report. We did believe that we set up that there would be, and this is a city attorney role, we set up that there should be hearings and mediation, and we should actually follow the rules. A lot of the complaints was that people didn't have an appeal process. I think you need to make the appeal process go fast. I also worked on inspection. I was meeting with a bunch of couple of business guys who were doing their 5th and 6th bar. They told me a story. They told me that they were putting a sink in a bathroom, and one inspector told them where it should go. They then had a second inspector who told them to move it to a new place. They did it. Money and time. And then a third inspector came in and told them to move it a third time. I put a resolution in. There can only be one inspector. If there's more than one inspector, then that inspector has to have only a serious health and safety violation if they're going to make them change it. Those kind of rules are all over the place that need to be fixed, and the city attorney needs to play that role.
The role of the city attorney with respect to the grand jury investigation was actually, we had a team that responded to the grand jury. And it became clear that the city does need to improve its permitting policies. And we've been working very closely with the city, as well as with the city administration and with the people in, which was formerly the CETA, to put in place the procedures and supervision and review that are necessary to bring this into the 21st century. One of the things that we discovered during the response time was that there were no policies or procedures in writing. And that is, of course, a problem.
Okay, Matt, do you have another one?
Yep.
Okay.
Sure. Well, according to city budgets, over the last 4 years, the city attorney's office has lost 20 full-time equivalent positions and seen its budget slashed from nearly $16 million to nearly $12 million. What can the city attorney do to safeguard funding?
Or deal with the budget problems?
Safeguard funding for the office.
Okay.
Well, we're doing everything we can. We went to the council and explained to them a year ago that, in fact, by cutting our office, we would be losing money in the city because it actually requires us to hire more expensive outside counsel. As I indicated before, you can spend $250,000 for a motion for summary judgment by an outside attorney, and the cost of a full-time attorney in our office to work for an entire year and handle that and many other matters is less than that. Therefore, what we've been doing, and we did persuade 4 members of the council to support us, is to show that by bringing attorneys in-house, the city will actually save money and thereby have more money available for infrastructure and programs and services.
I think you have to do many things. I think you may have to add some city attorneys, but I think you also have to streamline the city attorney's office. You have to stop and think, do we need more attorneys? Or do we need services? Do we need police officers? It is a balancing act. Do we need to do settlements differently? Do we need to do litigation differently? Do we run the office differently? I think it's not as simple as just protecting your budget. Everyone has done more with less, and I think the city attorney's office needs to do more with less also.
So this will be the last question, and then the candidates will have closing statements. So a new city council will take office in 2013 with at least some new members. How will you approach establishing a good working relationship with the new council?
I will work with everyone. When I was president of the council for 2 years, I had an excellent relationship with the city council members. I am a consensus builder, and I'm a team builder, and I will work with everyone. I think the problem with the city council is there needs to be more dialogue with each other, and there needs to be leadership to move forward in a consensus way. But I think that there will be easily able to work with every council member on the city council.
As the Chief Assistant City Attorney for more than 10 years, I provided advice at council meetings, and I worked closely with the council members, and now as City Attorney for the last year, I'm continuing to do that. I have credibility, I have the judgment and experience, and I'm impartial, and the council, and each council member relies upon me. When council members come to the city as new council members, we give them an orientation, we explain all of the key aspects of the city laws, the charter, the sunshine ordinance, etc. And we will continue to do that, and we meet with them regularly. I personally meet with them to develop that rapport, and I am an excellent person at consensus building and collaboration.
So you can just stay standing up for your closing statement. You have 1 minute for a closing statement, whatever you want to talk about.
Okay. Thank you so much for hosting this forum. The city attorney's position is not about politics. It requires judgment, experience, and expertise over a broad spectrum. That is what I bring to this job. Law is my profession. I've been a practicing full-time attorney for more than 35 years. I advise every department of the city. I was an assistant U.S. attorney. I worked for 2 major corporations and 2 prominent international firms. My vision is to continue to be a force for change in our neighborhoods and in City Hall.
I have been a civil rights and labor attorney for 25 years. I believe the city attorney's office needs to change. It is bureaucratic. It takes much too long to get things done. I am known for getting things done. I want to work with people to be more responsive. The settlements, I believe the settlements need to be done earlier. Example of Cheryl Thompson, where the settlement, there was a settlement, $500,000 was spent on defending her case, and then eventually, because it was going to cost so much for going to trial, they wanted to spend $450,000 to settle with her. I voted no. Settlements, we will do them early. I will be an activist attorney working with the community on elder abuse, workers' rights clinics, foreclosures. I believe I have the legal background. I believe I am a fighter. I'm an implementer, and I will bring change. And I will be a leader as a city attorney, a professional, and I will also understand the politics that is going on in the city. Thank you.
On behalf of the League of Women Voters of Oakland and the Oakland Metropolitan Chamber of Commerce, I want to thank everybody for coming to tonight's forum. Remember to vote on November 6th and encourage all of your friends and neighbors to do so too. There's great information at the back table about smartvoter.org and the League of Women Voters. Thank you all.
Mayor, so we want to let the folks get a picture.